This is
Welcome to Bankruptcy Through the Looking Glass with Barry Levine.
Bankruptcy Through the Looking Glass with Barry Levine. Barry, thank you so much for being here today.
Katie, always my pleasure.
Thank you. Well, I'm Katie Roberts, and we have a really interesting episode today. It is the power of protection, becoming judgment-proof before it's too late. Barry, I've actually never heard of the term judgment-proof before. Can you explain what judgment-proof means and why the concept is important in the context of bankruptcy?
Sure, it's always best. Being judgment-proof is that you have no assets from which a creditor can satisfy their judgment. And if you're filing a bankruptcy, granted, it's always a case of how you do it. Very often people, will convey it for $1, love and affection and all this other bullshit, but it doesn't really work. But, if you actually can make yourself judgment proof, which is sort of, it should be a better term for what we're talking about. But, you can go through, what can creditors do to you? I mean, it's, most of my Chapter 7 candidates or clients, through no fault of their own are judgment proof because their assets are below the exemptions that you're entitled to in a bankruptcy. But if you're somebody, let's say, who is in business or, have a lot of assets, you may want to consider protecting them, getting rid of them so that if creditors come after you, there's nothing for them to get.
So when you say getting rid of, is that like letting a friend hold on to something or selling?
Well, the thing is, you have to do it. Everything has to be tied into consideration. You have to avoid doing fraudulent conveyances. And by fraudulent conveyances, I'm talking about, civilly, where you're taking an asset that could go to all your creditors and you're conveying it to your buddy for love and affection. In these video blogs, I always give examples. Right now, I have a client who's in a Chapter 11, and he was being chased. Both he and his business were being chased by a person who became a creditor. And in my opinion, they should have thought about, tightening things up, looking at what is at risk when it started or even when he started the business. It's very difficult when you try to make yourself judgment proof right when the problem arises.
That's interesting. Okay, so as soon as creditors start reaching out or you feel that you're in between a rock and a hard place is when you can start protecting yourself?
I happen to think that you should try to do that. What's the legal phrase? Ab initio or some such stupidity, right from the beginning. It's like, it reminds me of the joke where they were looking for this Jewish woman's husband and at the cemetery and they couldn't find him. And she said, "Well, look under my name." Why? He puts everything in her name. I mean, there's a certain utility to that. What I mean? But you have to do it at a point. In Massachusetts, there's a 4-year fraudulent statute conveyance, where they could set it aside as a fraudulent conveyance. So, which is why I say, and if you're going to talk to a creditor's attorney, I'm sure they'll totally disagree with me, but which is why I say you need to do it sooner than later.
Right.
In someplace, my website, I said, when the shit hits the fan, is not the time to think about doing something like that.
Yes, it's far gone. An ounce of preservation is worth a pound of cure. It's what it sounds like specifically in this.
No, you're absolutely right.
Okay, so if you could paint an example, I just want to better understand what steps can an individual take just to make themselves judgment proof.
They have to look at what type of exposure they have. Do they have assets that are waiting there to be plucked? I mean, do they have stock in their name? And I'm not suggesting that maybe you have to do it. It all has to be kosher. You just can't convey it for love and affection for $1. You have to look at it like, for instance, if you happen to have, like, very often people set up a small business and they have friends who lend them money, or their parents lend them money. Why shouldn't their parents or friends be a creditor like everybody else? And why shouldn't they necessarily have a mortgage or a security interest securing their money? I mean, just because they're family, they should be protected like any other creditor. And the thing is, if you decide to put mom and dad, give them a mortgage, they're, from a bankruptcy point of view, they're considered an insider. So you have to wait out a year before they become, their position becomes kosher. It's, I don't know if you understand what if you grant them a mortgage on a debt that already exists, they're insiders because they're family members. So you have to wait a year before their mortgage could be set aside as a preference. After a year, it becomes kosher, for lack of a better word.
So are you saying that if your mom and dad are creditors, part of the business, and they have an extra year to future-proof or judgment-proof?
To perfect their position, yes. I
Perfect.
mean, a friend, it's 90 days.
Interesting.
So, and the thing is, on the other hand, if mom and dad or a friend lend you money and simultaneously you grant them a mortgage, that's copacetic because they're giving you value and you're lending them. You're giving them a lien on your assets. It's when you decide to button things up, you owe mom and dad $500,000 and you put a mortgage on the house, you have to wait a period of time.
Okay, so I am curious, if you do have friends, family involved in this entire process, what is expected of them other than providing documents of money loaned? That's
basically it. I mean, they always, it's like people always, putting mortgages on something or securing something is always a way to eat up equity. And, I tell clients I can put as many mortgages as I want on your house. If somebody asks, show me the checks, I have to be able to show checks. I mean, mortgages are meaningless. But I'm a cynic.
I love that. That's great. Are there specific assets or strategies that are considered protected from creditors in these judgment-proof scenarios?
Well, I mean, it depends on, where you're living. Massachusetts, and I really speak to Massachusetts. I was looking someplace, they had a homestead, and, because Massachusetts, the one real benefit, when you file a bankruptcy, you can take either the state or federal exemptions. And the Massachusetts homestead exemption, which is a state exemption, is $500,000, which, when some person files bankruptcy, it almost, I have situations where, they go to somebody for some sort of trust, a self-settled trust. I remember my parents did this. It was like nonsense. That's just my opinion. People may disagree with me. The thing is, what it does, it'll take a piece of property that's protected by the homestead. And if you're in Massachusetts, if you're talking about people over 62, it goes up to $1 million. And, they'll put it into a self-settled trust with the trustees and the beneficiaries, which means it's not really a trust, but that's neither here nor there. And it just makes life more complex. Fortunately in Massachusetts, beneficiaries of a trust can now avail themselves of the homestead, where there was a time when they couldn't. But one of the ridiculous idiosyncrasies, and there are a lot in Massachusetts, but I won't get into that. I could talk about French rolls at Chinese restaurants, but that's, and knives, it's a very special thing. The thing is, in Massachusetts, when you turn 62, your $500,000 protection goes up to $1 million. But because it's a source of funds, you need to file a new homestead, when you turn 62, because silly me, I would think if you file one at 45 and you live to 62, it should be automatic, but you have to pay another fee.
Interesting. I'm curious because the age 62 is so close to the age of retirement. Is that strategic?
That's whatever the legislature said. I have no idea. At one point, I've been doing this for probably longer than you were born. The homestead has gone from like bupkis to the $500,000. There was a point where, and the real for people when they have to look at it and when they have real estate is some states, the homestead exemption is basically non-existent. Massachusetts happens to be very beneficial, so much so that there are two types of homesteads in Massachusetts. There's the one that you record, which gets you the $500,000, and then there's an automatic homestead, which, and don't hold me to it, is either 100 and a quarter or 150. I don't recall because I always record one for my clients. But under bankruptcy law here, you're entitled, let's say you have a home someplace else that you want to retire to. You're entitled to apply that unrecorded homestead exemption to property in another state. I had a client who did that. He planned on moving. He lived here in, I think it was Saugus, Massachusetts, a cute little town. He was moving to Maine. He had a place in Maine, and we applied the homestead to his property in Maine. America's a wonderful place.
I am curious, in Massachusetts specifically, do creditors look at assets and liabilities any differently, or is it just all assets?
It's all like one big, I guess I could say sum. It is what it is. From an asset point of view, we can't make up numbers. We provide an appraisal and things like that. But, creditors sometimes can look all they want, and another in Massachusetts, like I have a case now where these people have been, when you get an execution, a judgment is good for 20 years, and you can record an execution at the Registry of Deeds. It's only good, and somebody out there is a real estate attorney in Massachusetts, for 6 years, but you can re-record it. So these two gentlemen, by now their judgment is $1 million. They've re-recorded it at least 3 times, but their claim is only against the husband on a piece of property that's owned by husband and wife. And in Massachusetts, while they can record a judgment like they have, even though they've received zilch, there's nothing they can do with it. They can't force a sale of the property. They really have to hope that the wife dies before her husband, because then the interest would vest with him. And they'd have, yeah, that's, you haven't lived till you filed a suggestion of death in a case.
Very interesting loopholes. I'm curious, Barry, what are some of the top pitfalls that people will trap themselves in when they're trying to make themselves judgment proof?
It all comes down to, somebody's going to look. And, the sooner you do it, the better it is. If you wait for the day before or the day whenever, you have to avoid it. You have to do it for consideration and avoid it being set asideable as a fraudulent conveyance. Or the only other way, but, hindsight is 20/20, is not take the asset in your name to begin with. Put it in have a friend or set up a business. But, again, who's the stockholder of the business? Massachusetts, becoming judgment proof, you really have to be in a situation where if you file a bankruptcy, you're at risk of losing something. You know what I'm saying? Most people, you have exemptions, and even if you have 401k or an IRA or something, 99% of the time, no matter what's in it, it's exempt.
That's really interesting. I mean, it sounds like for each case, when an extra layer is involved, it's like a puzzle or a riddle that you're having to work through.
It's like fighting a war. The thing is, in the bankruptcy business, it all comes down to money. When I say it is what it is, my pen is only worth so much money. Your piece of real estate is worth so much money. Mm-hmm. So the confines of its value and the mortgages and the equity, so sometimes there's not a thing creditors can do about it.
Interesting. Do exemptions play a role in becoming judgment proof?
Well, that's basically what I've been talking about. It all relates to the exemptions. I mean, if you look at your assets, what you're entitled to exempt in a bankruptcy, that will tell you what you need to look at. It's called, I think, what's the phrase they use? Pre-bankruptcy planning. If you look at the exemptions and you sort of, make yourself fit into the exemptions.
My biggest takeaway from this is that don't procrastinate. When I ask the question, like pitfalls to avoid, just get it over with. It's not going to be fun, but the sooner you do it.
Well, it's not, the thing is, you probably even won't feel it. I mean, because 9 times out of 10, the asset's someplace else, but it really doesn't do anything or anything like that. It just looks good on a balance sheet, right? wipe your tuchus with. It's, but to me, the biggest problem is, it's like one of my others is the people who, come to me and say, oh, I just got a notice this morning. My house is being foreclosed on this afternoon. That doesn't occur. There's notices and all sorts of stuff. It's mishigas. It's the same thing. People who are looking to protect themselves need to plan. You need, it's like the trusts I was talking about. I think the selling point is they're planning to have no estate or life in trust, whatever it is. They need to plan in advance. And, this way, if they, maybe they never have to file a bankruptcy, they never have to concern themselves. But, if the shit does hit the fan, they're prepared to withstand it.
I love that. And it rhymed.
I can show you my poetry. In high school, I was the head of the literary magazine.
Really?
My line of bullshit goes for miles.
Oh, yeah, it's fun. I love writing as well.
Told me I should write for TV.
I would love that. One last question, Barry. What role does a bankruptcy attorney play in helping someone navigate the process of becoming judgment proof? And when should the attorney get involved?
Well, it would be best if they didn't get us involved at all. Because listen, you can do a lot of this stuff yourself. But getting involved is as soon as you're thinking about doing something. I mean, consult with an attorney, be it me, be it somebody else. Look what your exposure is and try to create a situation where you can withstand the shit hitting the fan. Like I said, it may never come to pass. It prepares to prepare.
Yeah, it definitely does. Barry, this has been so informative. Thank you so much for your time.
My pleasure.
And to our viewers, thank you for joining us on Bankruptcy Through the Looking Glass.
I think I always end, so you're new here, I always end with sei gesund, which means stay healthy.
I love it. Stay healthy. You can connect with Barry at levineslaw.com. Be sure to follow, subscribe, comment, and review on your favorite platform. We love having you as a part of our community. Barry, thanks again for being here.
My pleasure.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.